Good morning. I'm Alexandra Lopez, immigration attorney. It is Monday, August 11th, and we all know that USCIS has issued updates to its policy manual regarding family-based immigration petitions. And a lot of the concern was around USCIS issuing notices to appear. But some other changes that were made were also updates to when interviews were going to be required across the board when filing a family-based I-130. So I wanted to address these changes and tell you when USCIS will require an interview for these standalone family-based petitions, okay? So let's go through these categories one by one. The first circumstance in which an interview will always be required is when there is evidence missing or the record indicates that a marriage is not bona fide, right? So something about that petition leads the USCIS officer to believe that something isn't right, the marriage isn't bona fide, there's a lot of evidence missing, they're going to call you in for an interview. 2, there are material inconsistencies or derogatory information, so things that just don't add up, right? Material inconsistencies, you say one thing, one date or one thing on one application, and then on a subsequent one, you say something different. 3, petitions for a spouse where either spouse or both spouses were under the age of 16 at the time of the marriage. They're screening for fraud here. So age, 16 or younger, you're going to be called in for an interview. Petitions for a spouse where one spouse was 16 or 17 years of age and the other was at least 10 years older at the time of the marriage celebration. So big age discrepancy, specifically, 16, 17, and 26, 27 or up. They're going to screen for fraud there. So you'll be called in for an interview. Next, petitions that lack reliable documentary evidence to demonstrate the existence of a qualifying relationship after an officer has issued an RFE or an NOID. So this, or notice of intent to deny. So this isn't necessarily only family-based. They're saying existence of a qualifying relationship after a request for evidence. So we've issued a request for evidence, something is missing, we aren't convinced that this is a qualifying relationship. We've issued a notice of intent to deny, and you still are lacking that documentary evidence. We're going to call you in for an interview. This can happen in parent-child petitions as well, specifically where the parent is the father and maybe there's a lack of a DNA test, there's an established parentage. So we're not excluding this only to marriage-based petitions. Next, petitions where testimony is needed to resolve discrepancies in the record or to address concerns regarding reliability or credibility of evidence following an RFE. Again, inconsistencies. We asked for the RFE. It's still not making sense. You're going to get an interview. Petitions for a spouse where the petitioner previously filed a spousal petition for a different beneficiary. So your spouse is a U.S. citizen who's petitioning for you, but they've also petitioned for 3 other spouses. They're going to assume fraud. They're going to call you in for an interview. Petitions for a spouse where either the petitioner or beneficiary was a party to a prior denied, revoked, terminated, or withdrawn spousal petition. So if either of you have ever done this process before and it was not approved, it ended any which way, it was denied, you revoked it, it was terminated because you didn't proceed, or you decided to withdraw it, either you or your spouse, you're going to get called in for an interview. Petitions for a spouse where the LPR petitioner, so the spouse who's petitioning for their spouse, is a permanent resident, and they acquired their permanent resident status through marriage less than 5 years prior to filing. So they became a permanent resident less than 5 years ago through a prior marriage, and now they're petitioning for someone else. They're going to be called in for an interview. Petitions for a spouse where the marriage occurred while the beneficiary was in removal proceedings. So you and your now spouse were dating, you got placed in removal proceedings, and that was the spark you needed to, formalize the relationship and get married. They're going to call you in. They're going to assume there's fraud there. There's often not fraud, but they're going to assume that there's fraud. Petitions for a spouse that are adjudicated where, following an initial interview, it is determined that the bona fides of the marriage are in question. So this is when there's already been an interview and they're going to call you in for another one because something happened during that interview. They were not convinced that this is a legitimate marriage, and oftentimes that second interview is separated. It's what's called a Stokes interview, and they question the spouses separately. Okay, so those are the situations where always you are guaranteed now that you will be called in for an interview, at least pursuant to the new USCIS policy manual, the updated one. This is when they're going to be requiring interviews.